Thank you so much for having me on the call. I'm going to get right to this because I know everyone's waiting and I want everyone out there to get paper, pen, get focused, take notes. On with the show. Real estate investors, your asset protection should be specifically for real estate with total protection, without adverse tax results, without high IRS audit risk, without over complexity, without costing a fortune, no bad side effects. But whether delivered as a service or a home study course, it is not until now. Welcome to Extraordinary Asset Protection Strategies with no costly side effects, no side effects, no nausea, no vomiting, no headaches, no dizziness, no body odor. You hear all these side effects. Well, this is no side effects, guys. Protecting you from wrongful creditors, money-hungry lawyers, expensive lawsuits, costly partner disputes, the courts, IRS, and other vultures without expensive lawyers making the legal system work in your favor. Is that music to your ears? I know this is not a sexy topic, but we'll make it X-rated. And by the way, again, we're going to make the legal system work in your favor because the legal system is designed for lawyers. Well, we're going to change that. Now, this is about me and that you heard in the introduction, but let me just tell you a little bit more how I got into this. When I first got on the national real estate circuit over 10 years ago, teaching tax reduction strategies, typically on the same event, there would be someone else, usually an attorney, teaching asset protection. Now, for the most part, they were very good with brilliant legal minds. But as I started to listen very carefully, I found negative gaps in their teaching, such as rarely addressing the tax consequences of an asset protection vehicle or technique, which tax consequences could be detrimental. They also did not consider the IRS audit risk, which could be high with an expensive, time-consuming audit. Moreover, their legal protection structures were frequently overly complex and expensive. And despite their expensive complexity, they often did not totally protect you. So they didn't give you the full picture. Too many bad side effects. So I decided to do something about it. Having taught entities in asset protection at graduate tax programs, I took action to solve these negative issues and close the gaps. I put together a legal team with myself, also experienced real estate investors, to thoroughly research every LLC statute, all 50 and DC, cumbersome textbooks, the applicable IRS regulations, and other relevant asset protection sources. After long, tedious hours of this research and development, we now have this updated, newly revised asset protection presentation. Now, real estate investors, you can be sued by anyone, anytime, for any reason. Even if you do everything right, you're totally innocent. You should do everything right, but you still can be sued. 82,000 lawsuits filed daily in the United States. This is a multi-billion-dollar business for lawyers. And many of these lawsuits are frivolous, meaning they have no economic substance, but they still are real. So it's not if, it's when. And the target is your personal assets and the equity in your property. We're going to tell you how to protect everything. One lawsuit can wipe out you and your family, and we're going to go through some case studies. Now, even if you win the lawsuit, you could still be wiped out by the legal costs and business losses, which happen so often. Again, the only ones who win in a legal action are lawyers. We're going to change that. We're going to make you the winner. Now, real estate is a high, let me backtrack. With the proper education, real estate is a high return, low risk investment. But I'm not talking about return risk. I'm talking about liability risk. It's a high liability risk asset interacting with tenants, contractors, others who can sue you, and real estate is also subject to many regulations. The insurance myth. Okay, I read this on a blog not long ago. Quote, my lawyer said umbrella insurance is enough to protect me. I do not need an LLC. Let me tell you something. With lawyers like that, who needs enemies? Now, absolutely, you should have liability insurance, but it does not protect you from legal disputes with tenants, over rent increases, and there have been massive lawsuits over rent increases, or evictions, or unpaid rent, or the refrigerator's not working, or I have emotional stress, you name it. Tenants are also called aliens from outer space. All right, the next aliens, contractors, over work performed or not performed, materials used or not used, whatever. Partners over who gets what, who does what, who makes this decision, who makes that decision. Same thing with family members. Vendors over pricing, whatever, and others you deal with. All that can lead to costly, time-consuming, aggravating lawsuits. Insurance also does not protect you against these potentially significant liabilities: environmental, lead paint, radon, asbestos, mold, name it. A properly structured asset protection plan can protect you from these fair housing violations, even unintentional innocent ones. Insurance does not pay you for attorney fees and court costs related to these uninsured legal actions. Insurance does not protect you against liability claims that exceed limits, and this happens very frequently, even high umbrella limits, and other claims that the insurance company says are not covered that you thought were covered. Insurance also does not prevent lawsuits from ever happening. Lawsuit prevention. A lot of this discussion is on lawsuit prevention, preventing lawsuits from happening in the first place. Unlike a properly structured and documented LLC, insurance also does not give you financial privacy, which is the cornerstone of asset protection and lawsuit prevention. Now, when I say financial privacy, I don't mean hiding out in the mountains like an outlaw. It's privatizing your family transactions, which you have the right to do and should do. Insurance will not defend you in a costly, time-consuming audit against the most powerful predator-creditor, IRS. Insurance will not support tax-saving strategies. A properly structured LLC and asset protection plan gives you these protection benefits that insurance does not. All right, let's talk about the hidden powers of limited liability companies to save you thousands. Now, by the way, this is for new LLCs if you're just starting out, or if you already have an LLC, existing LLCs, it's for that too. And by the way, it's going to include how to get a free LLC set up, and we got some other great bonuses as well. Now let's define an LLC, a limited liability company, is a hybrid business entity filed under state law in which all partner owners, called members or managers, have limited legal liability. The key word there is hybrid, combining many great features and benefits. An LLC has the major advantages of other entities, yet avoids their pitfalls, and that's the key to a properly structured LLC. LLCs have the limited liability of a corporation, yet avoid corporation tax pitfalls as a primary entity for real estate. We're going to discuss some of these pitfalls. LLCs have the great tax advantages of a general partnership, yet avoid the personal liability of a general partnership. Unlike limited partnerships, LPs, all LLC members can participate in management and not lose their limited liability status. LLC members can save taxes by planning not to be subject to IRS passive loss limits, so they can fully deduct their rental property tax losses against their other income. That's huge. That's huge. Now, limited partnerships and family limited partnerships cannot do this. Many CPAs and attorneys don't know this, but they are totally subject to the passive loss limits, where you would not be able to take your property tax losses, such as from depreciation, against your other income. LLCs are not subject to the huge tax pitfalls of an S corporation. Now, here's a question. What does the S in S corporation stand for? Right there, guys. You got it. Why? S corps are the most litigated entity with high IRS audit risk and tax court litigation, where the taxpayer almost always loses. Who would want that? I would stop right there. But there's more pitfalls. IRS requires the S corp to pay you highly taxed W-2 salaries, highest tax income, with payroll garbage, down the drain taxes, and pain in the neck filings. There are limits on deducting S corp loss against your other income. It is not a total flow-through entity. And tax-free loans that are refinanced could be taxable that are normally tax-free. Do I have to say any more? Despite what you have been wrongly told, avoid S corporations for real estate keepers and flippers. The above S corp pitfalls do not pertain I'm going to explain what an LLC partnership is, but do not pertain to an LLC partnership. And this is all fully supported by tax law citations. Understand, what I'm teaching you is based on factual data. This is not my opinion. LLCs, in short, are far superior to sole proprietorships, general partnerships, limited partnerships, family limited partnerships, S corporations. Land trust is a primary entity, although you could combine an LLC with a land trust, and C corps as a primary entity, and I'm going to show you how you could combine an LLC with the C corp. LLCs have little, if any, disadvantages, provided they are set up and documented in the right manner, which most are not. All right, let's talk about some entity and asset protection strategies. Take notes here. Now, for new LLCs, the general rule is the formation state should be the state of the property's physical location, not an outside state like Nevada or Wyoming. I know you've been told by some Nevada promoter trying to rip you off to form in Nevada. Let me give you the reason. The courts of the property's physical location will have primary jurisdiction over legal actions, not the outside state. Plus, there's more costs and paperwork, such as foreign entity registrations. For example, if you form your LLC in Nevada and own properties in New Jersey, you must file and pay for a foreign entity registration with New Jersey in order to do business in New Jersey. The better way would be to make New Jersey, not Nevada, the LLC formation state with no foreign entity registrations necessary. Foreign entity registrations, besides the paperwork, could be expensive. Hang in, I'm going to tell you how to avoid them even further than what I just discussed. Now let's talk about entity selection. Now, entity selection is not based on arbitrary opinion. Instead, it's based on current factual data, looking at the three sides of an entity. And this is important to understand. The first side is the legal side. Well, that's governed mainly by state law. If we're talking about an LLC, we're talking about LLC statute. Two, the tax side is governed by IRS tax law provisions. And three, the IRS side is governed by audit statistics as to which entities get audited the most versus those who get audited the least. I know you want to know that. So logically, we want to create the right structure that has the best of all three sides. Legally protects your assets the best, saves you the most taxes, best audit proofs of return against the IRS. And for real estate, it is a limited liability company elected to be taxed as a partnership. Write that down. Limited liability elected to be taxed as a partnership. It's one entity, an LLC partnership. On the legal side, it gives you limited liability, protecting your personal assets. On the tax side, partnership is the most favorable flow-through tax benefits for real estate. I know this from teaching semesters of it and using partnerships. And IRS side, low IRS audit profile, files Form 1065, not highly audited Schedule C or E. Schedule C's or E's, IRS schedules, C or E's, are the most audited schedules. IRS agents would rather audit those schedules than go to heaven. Okay. With the superior entity, you separate your real estate business activities from your personal activities, both legally and tax-wise, on your 1040. So let's look at that. Your 1040, no highly audited IRS Schedule C's or E's, clean 1040, separate. Your LLC partnership, Form 1065, with low audit profile, owning all the properties. Now, even though that LLC partnership is legally and tax-wise separate from you, the benefits, the tax benefits, will still flow through to your 1040. In fact, the LLC partnership is the only pure flow-through entity. Now, you want to avoid single-member LLCs, also called disregarded LLC, where there's only one member, you. Why? Legally, there's much more chance of the entity veil being pierced, exposing your personal assets, and much higher IRS audit risk. Guess what schedules single-member LLCs file? Nasty Schedule C's or E's. You want to avoid them. Now, if you need a partner, because a partnership is two or more legal persons, if you need a partner to create the partnership, hey, below can be a partner. You know, they could be a 1 or 2% partner you control. Your spouse could be a partner. Another family member could be a partner, or even another entity you own such as a C corporation, even though you own the entity, can be a partner. So let's explain this. Your own C corporation could be a 2% partner member of the LLC with you as the 98% majority member to create the LLC partnership with you and your C corp as the partner members. Here we have our LLC partnership entity. You're the 98% majority member partner. The C corp is a 2% minority member partner. What's this mean? This means additional deductions. See, C corporations have special deductions and benefits that other entities don't have. So we could get these special C corp tax-free deductions, yet without C corporation tax disadvantages, because we're only making the C corp a 2% member. They're not a primary entity. So we're getting the best by doing this. We're getting the best out of the C corp, but avoiding its pitfalls. And you know, this is the art of entity structuring, is to avoid the pitfalls of an entity, but to get the best out of it. You know, it's kind of like taking a loaf of bread that's mainly tainted, except for one delicious, nutritious slice. We're just taking out that one beneficial slice and discarding the rest of the loaf of the bread. The bottom line, by using a C corp as a minority 2% member of your LLC partnership, my students are saving an average of $3,000 to $8,000 a year, and it's still all your money going from one pocket to another. Plus, there's no corporate tax pitfalls. The C corp, as I explained to you, is because it's a 2% minority member. There's IRS audit proofing, Form 1065, asset protection with an LLC corporation, and the C corp can be a Wyoming entity because the C corp has a very limited role. It does not own any property. In fact, we call it a barely breathing C corp, just primarily to get its benefits and avoid its detriments. This equals limited liability protection, the best flow-through tax benefits, low IRS audit risk, best of all worlds. You're going to save thousands. How many people are liking that? Yes, I can see that. Plus, by having an LLC entity properly set up, beginning investors can fully and safely deduct real estate education, even if you have not closed on a transaction, even if you did not have an LLC at the time you incurred the above expenses. How about that one, guys? It's all knowing how. We're going to talk a little bit more about this later, because I know that's a big dilemma with beginning investors. Well, we're going to solve it. Now, what's required for an LLC to be properly structured to protect you in so many ways? Well, before getting to that, let's get to this. Veil piercing. Now, veil piercing, or piercing the veil, is when a court ignores the entity and reaches the personal assets of the members. And the fact is that veil piercing is the best and most common enemy weapon for collapsing the small LLCs, which most of us are, and exposing your personal assets to attachment. Now, write this down. The kryptonite to prevent veil piercing and protect your personal assets, write this down: entity formality with complete, properly worded legal documentation for your LLC. Entity formality with complete, properly worded legal documentation for your LLC. That equals you're not the LLC and the LLC is not you. That's the key. You're totally separate. Once you have that set up with the right formality and documentation, they cannot pierce your veil. Here's a question. The Articles of Organization, which sets up your LLC with the formation state, is the most important LLC document. Is that true or false? I see some people saying true, some saying false, and some who are saying trolls, which means they don't know. All right, it's false. The articles are only your application for your LLC setup and the formation state. That's it. While they are the only public LLC document, they do not govern LLC operations in any way. They do not determine who the members are. Even when you form the LLC, you put member A on the articles. Once you start your LLC, member A doesn't have to be the member. It could be member B, C, whoever. Now, the four most important LLC documents, legal documents, and write this down, that govern LLC operations and determine who the members are and protect their assets are: 1, the operating agreement; 2, minutes of meetings; 3, LLC certificates of ownership; 4, resolutions. I'm going to explain these. Now, the operating agreement, the OA, is the nuclear governing instrument that mandates LLC operations and determines who the real member owners are. It is the heart and soul of the LLC. A properly designed operating agreement is to be specifically targeted for real estate, because real estate is a separate business unto its own compared to other businesses. Real estate has its very own legal aspects, its own tax aspects, its own IRS aspects. They have to be addressed separately to get the best benefits. All right, comprehensive by including every legal facet of your real estate investment operations, essential for ironclad protection. A properly designed operating agreement should also include tax provisions that authorize and support a multitude of real estate tax saving strategies completely backed up by tax law sites, along with total IRS compliance to ensure your LLC is operating legally within IRS regulations. You don't want to play with those boys, guys. You got to have it right. There's no one or thing or whatever you want to call it more powerful than the IRS. So we want to comply. Also, every LLC statute requires minutes of meetings as an important entity formalities. The courts state that actions without minutes can make the LLC members personally liable or bind the LLC to unwanted transactions. Who wants that? Now, here's a tax tip. Have your documented LLC meeting in a nice travel location, deduct the trip, and let the tax savings pay for the trip. How about that one? Now, by the way, when you travel away on business, you can deduct almost everything, even the dry cleaning of your personal clothing. So wear dirty clothes. All right, let's move on. Now, the next important LLC document is the LLC membership certificate, like a stock certificate, shares in a corporation. In the LLC, we call them units. So units, shares, certificates, interchangeably, we use them. They evidence your ownership in the LLC to prevent all kinds of costly, time-consuming legal disputes and to protect you as well. We're going to show you a case study. The last important LLC document, resolutions. Now, these are written records of the members without in-person meetings authorizing important LLC decisions, such as buying or selling a property. This is an essential part of entity formality to prevent the veil piercing. Legal side, without such documents and formalities, your LLC can be collapsed with your personal assets totally exposed, especially the small LLCs. The tax side, the powerful IRS, they want to collapse you too, and collapse the LLC to disallow deductions, education, travel, meals, entertainment, all these that can amount to thousands, and you can lose thousands, and there are many tax court cases where this has happened. All right, let's go to the next strategy. Protect your property equity within the LLC entity via equity stripping, using debt to eliminate property equity as a deterrent, lawsuit prevention, deterrent to ward off wrongful creditors and their lawyers. By the way, when I say a wrongful creditor, this is one who should not be paid because they are not the right creditor to begin with, or they did not do the job properly, or somehow tried to rip you off in some way. Now, how many people heard of equity stripping? Okay. Well, how many heard of stripping? Okay, all right, we'll define it, guys. Before we get to that, here's the problem. While a properly structured LLC protects your personal assets outside the LLC, it does not protect your equity within the LLC. No entity does this. Now, many out there, including asset protection gurus, don't even know this. You hear people talk about different entities totally protecting you. No entity protects the equity, your real estate equity within the LLC. So, for example, suppose you have $100,000 equity in your property. That's a big target for claimants. Hey, even $30,000 is a prime target, like blood for sharks. Now, for multiple properties, the typical advice to protect equity is an LLC for every property. But as you know, that's going to get, especially when you get into numerous properties, that's going to be very expensive and time-consuming. It is not necessary to have an LLC for every property. To protect property equity is the good news. You could use one real estate LLC partnership for all your properties, keepers and non-dealer flippers in the same LLC entity. Now, I know you've been told to use a separate entity for your flips. Well, that's dealer flips. In our tax courses, we teach you how to avoid being a dealer. So these are non-dealer flips merged together with the keepers and the non-dealer flippers. Multiple LLCs do not totally remove the equity. They only segment the equity into a smaller size. Let's look at an example. Suppose you have $300,000 equity in 6 properties, and let's assume it's the same, even over 6 properties. It's $50,000 equity each property in 6 separate LLCs. You still have $50,000 in equity in each LLC, which over time is going to grow to a larger size. There's appreciation, there's upgrading, forced appreciation, mortgage amortization, etc. So that equity is going to grow. The low-cost solution is equity stripping. Totally removes the equity, including future appreciation. 2 LLCs to protect any number of properties in any number of states. The best, the cheapest, and only way that I know to protect your property equity. Now let's define. Equity stripping is using another second LLC. We got our real estate LLC. So we're going to use another second LLC that we call the lender LLC to create secured loans on properties in your real estate LLC, so there is no equity, no target for wrongful creditors, money-hungry lawyers, and other such demons. Equity stripping is like getting a secure loan from an outside lender, except here the lender is your own company. So here's what we have. A valid secured debt between 2 separate state statutory entities. Look under the real estate LLC. There's no equity. It's gone. There's no target. Where is the equity? Well, after the lender LLC affected the loan, now they own the mortgage receivable. They have it. So it's paper equity. Your equity is still there. It's just been transferred to a safe place. Now, the lender LLC can be in Wyoming. Excellent privacy, low state fees. In fact, Wyoming is even better than Nevada. Now, why is Nevada, I get this question, why is Nevada more, more popular, more known? Well, my theory is that Nevada has Vegas and Wyoming has Yellowstone National Park, which means more people would rather commit sin than get a little history. All right, so Wyoming, fabulous privacy, the best, because it, and by the way, it only owns paper, the mortgage receivable, so there's no filing of foreign registrations. The lender LLC is not reachable by claimants. Wyoming privacy, owning a non-risk asset. Someone had asked me, they were trying to find somebody who owned a Wyoming LLC, and I couldn't find them. I said, no, you won't. It's private. So the Wyoming LLC here, the lender LLC, owns paper. This is non-risk. There's no lawsuits with paper. There's no tenants, no contractors, no fair housing violations, no slip and fall. Does not cause lawsuits. All right, with the secured loan, you have transferred your equity from a high-risk real estate LLC to a safe place, the lender Wyoming LLC. This is why we also call equity stripping equity transfer, because you're not losing your equity. You have it. You just transferred it to a very safe private place. Now, the equity stripping loan terms, no payments, including no interest. Now, there is interest at market rates, but you're going to accrue the interest and add it to the principal loan balance, so the equity stripping loan increases with property appreciation. It's beautiful. The equity stripping loan will be paid off when you liquidate and sell off all your properties, going from one pocket to the other. You still got your equity. Equity stripping does not adversely affect your credit report. You're not going to report yourself. Your cash flow, there's no payments. There is accrued interest, but it's a paper entry. Your equity, you still got your equity, just the pockets change. Remember, it's equity transfer. Refinancing, if you want to refinance with an outside lender, you can subordinate the equity stripping loan to a junior position. Doesn't adversely affect, an 1031 exchange doesn't adversely affect operating your business. Now, controlled equity stripping, where you control with your own lender LLC, can be done with your own funds, temporarily borrowed funds, or without any cash funds as part of the secured loan, stripping out the property equity in the real estate LLC. The end result is you have a big fat lien on your real estate, eroding the property equity and warding off claimants along with their money lust lawyers the way a cat scares off rats, and a pun is intended. Hurry. 2 or 3 LLCs are protected with any number of properties, any number of states. You're literally going to save thousands in legal fees, accounting fees, this fee, they fees, and the most valuable commodity, your time. Equity stripping is a prime example of effective lawsuit prevention that umbrella insurance or any insurance does not give you. These asset protection strategies, including equity stripping, are effective in all 50 states. You have to understand that, asset protection is an art as much as it is a science, maybe more so. Because the science would be use an LLC for every property. But then the art says, no, that doesn't make sense. It's not cost effective. And that's when we bring in equity stripping. Let's look at two actual case studies. Nancy from New Jersey, real estate agent on IRS Schedule C, no entity, and real estate investor on IRS Schedule E, no LLC. And this happens. Her real estate agent business went down, could not pay her bills. And then, when it rains and pours, someone severely injured on one of her properties, rental properties, so severe the claim exceeded her high insurance limits. Guys, this happens all the time. The costly consequences, legal actions from numerous creditors cost her $6,200 in legal fees. She did okay with the creditors, but she still had to fork out $6,200 to a lawyer. $55,000 judgment against her properties for the severe injury, total $61,200. Wow. And the time, the stress, and the aggravation, which is just as bad, maybe worse than the money. Second case study, couple from this was in the news, couple from South Korea came to the U.S., started a successful dry cleaning business. No entity, no anything. They got sued for a lost pair of pants by a claimant who happened to be a creepo judge for $54 million for a pair of pants. Now, what pair of pants could be worth that? Unless they have gold bullion in them. This is an example of this was a frivolous lawsuit. But when you see the costly consequences, yeah, they won the lawsuit. They even got their legal fees paid. But they lost their dry cleaning business, costing them tens of thousands of dollars, with their dream ending up in a nightmare. Tragic story. And there are thousands more of these disasters happening every day to people just like you and me. The average person gets sued 7 times in their lifetime, and that's the average person. If you're a real estate investor, it's going to be more. Now, what did these cases all have in common? Right. No entity, no LLC, you got it. Let's go through it. No entity, no documentation. Insurance did not protect them. Now, it may have protected Nancy to a certain degree, but not totally. Never thought it could ever happen to them. That's the big mistake. That's a big mistake people make. And it could have been easily prevented, saving them thousands. How many people do not want this to happen to you? Do I see everybody's hands going up? Now, if your hand's not going up, I can arrange it. All right, let's move on. Warning, attorneys, CPAs, Nevada promoters, and others. In fact, when you hear Nevada and entities grab your wallet and run the other way, sock you with big fees, yet use bare bones, worthless documents, you will pay the costly consequences. Your asset protection structure is set up wrong, a big target for expensive, time-consuming lawsuits and IRS audits, and you pay thousands of fees for this mess. Double indemnity. Who needs this? All right, how many people want a high-quality, low-cost solution without expensive lawyers where you have total control? Yes, I see everybody's hands going up. Sure. It's my newly recreated e-system, the LLC Master Machine Asset Protection System. Brand new automated software edition. And it's by myself, Al Ayala. I told you my credentials. Now, it's also my co-author, William Knoll. Bill Knoll is a tax attorney, CPA, former prosecutor, and criminal defense attorney. Brilliant CPA attorney. We're both real estate investors with combined experience of over 45 years. Combined tax, legal, real estate experience of over 45 years. It is the consummate asset protection system with extraordinary strategies covering every legal and tax component of a powerfully structured LLC shield with no adverse side effects, guys. No nausea, no vomiting, no headaches, no whatever. Without expensive lawyers, without overcomplexity, unlike any other asset protection source. The most powerful documents empowering your LLC to be an impenetrable fortress of asset protection. The Superstar document, the Master Machine operating agreement extraordinaire, adaptable for all 50 states and DC, specifically targeted for real estate. Remember I told you how important that is. It's 121 pages of platinum gold to simultaneously give you an ironclad legal shield, support for tax savings, effective IRS audit defense, protective legal provisions saving you from disputes with tenants, contractors, partners, families, and others that would turn into costly, time-eating lawsuits. Here's a partial list of the provision headings of the OA Extraordinaire. I'm not going to read them all. Your specific business purpose, that's important. Real estate investment intent, that helps avoid being a dealer. Investments not permitted, profit and loss, cash distributions, entities as members, SEC representations, loans by members. What happens if there's bankruptcy or divorce or death or incompetency? Limited liability with voting rights. Specific duties a member should do, duties a member should not do. That's very important for limited liability protection. Transfer of property to LLC with an existing mortgage. Exemptions from transfer fees. Member management of property in accordance with fair housing laws. Again, I'm not going to read all these. Actions without meetings. Confidential information. No commingling of funds. You don't want that. Company insurance. C Corp is 2% minority member. And so many other protective provisions. The operating agreement alone is worth $10,000, and that comes from Lee Parker, entrepreneur out of Alaska. The LLC Master Machine Protection System has the absolute best operating agreement. It is packed full of the details that you need to protect yourself and your assets. We find it extremely comprehensive and helpful, and that comes from a lovely couple, Kurt and Tanya Kufner from Minnesota. And that's Kurt at the garmaxgroup.com. 35 tax provisions authorizing and supporting a multitude of real estate tax saving strategies. Here's the partial list. You want to be a partnership. By the way, in blue are the IRS tax sites. You want your real estate to be a business. You don't want your rent to be subject to self-employment taxes. Got that covered. Component depreciation. We discussed this in our tax courses, but this is a way to triple and quadruple your non-cash depreciation deductions. Well, we have that authorized. Rehab improvements is fully deductible repairs. Sole intent is for profit. You do not want to be a hobby. All these tax credits, members to be active and not subject to passive loss limits. Again, I'm only highlighting here. Subject to mortgage interest deduction. Selling, exchanging property with investment intent to avoid dealer status. William Mallet Supreme Court case plus 36 tax court cases listed in the OA. What a blowout. Plus special provisions that authorize and support fully deducting real estate education, even if you're a beginner not yet owning any properties, even if you set up the LLC this year and pay for the education in prior years. A big problem with the IRS now solved with the operating agreement extraordinaire. Why? You have this legal entity, properly structured LLC, separate and apart from you, with this legal document, the OA extraordinaire, giving you legal authorization and support to do these tax strategies. I could tell you from hardcore experience, this is a powerful IRS defense. Name the round when you would win the audit. Plus, how to safely claim education on your tax return with the exact proper wording and tax law sites to scare IRS away. How about that one, guys? With this new system strategy and support, myself and my CPA are confident to fully and safely deduct my real estate education, saving me over $5,800 this year. That's from Adam, a beginning investor from New Jersey. Now, the problem is the time and effort in preparing these comprehensive legal documents or paying a lawyer to do them until now. We got it solved. For the first time, automated software, these powerful documents are instantly completed without manual preparation, simply by filling in a few blanks in a one-page AutoDoc input data form. Right here, you type in the LLC state, the date, the LLC form, the LLC name. Is this easy enough? It's easier than doing an application, mortgage application or something like that. Then you put member 1, their percentage interest, member 2, their percentage interest. If you have a third member, same thing. Put those in. How long did that take? Seconds. Hit submit. Bingo. The following documents are instantly and simultaneously generated without doing anything else. The operating agreement extraordinaire, all 121 pages. The minutes of the first members meeting. The minutes of the annual members meeting. You don't even know you had the meeting, but it's documented. The membership certificates in clear print for each member. Not like you get in these corporate kits where the certificates are in Martian script by lawyers from Mars who charge Martian prices. Are nice and clear. Resolutions, 14 of them, for 14 important LLC decisions without meetings. Not that you're having the meeting, but it's all documented. All right, it's all there. Plus, a special operating agreement for the C Corp. If you want to use the C Corp, you don't have to, but it's there to be the 2% minority member of your LLC, your real estate LLC. This is going to create more savings. Plus, automatically transfer your LLC membership interest, units or shares, out of your name into the privacy of a trust to protect your LLC ownership. You're going to see how important this is when I go over a case study, and other personal assets from costly lawsuits and probate. Let's explain. The LLC is a separate entity. That owns the real estate, not you. Once you transfer your membership units to the trust owns the membership shares, the units of the LLC, and other personal assets, not you. You own nothing, yet control everything, and this equals avoiding expensive lawsuits. How many people are loving this? Yes. And by the way, we also discussed the dangers of putting your personal assets into statutory entities other than trust. People have been recommended to put their personal assets in limited partnerships, family limited partnerships, corporations. That has dangerous, detrimental legal and tax ramifications. We tell you how to use the trust. Plus, how to quickly, automatically add or remove LLC members. All documents with proper legal language already done for you to protect you and your family. Prevent your LLC from being collapsed by the courts, IRS, other demons. Instantly completed without expensive lawyers. I mean, lawyers, I asked, would typically charge you $5,000 or more, and nowhere near the power of these extraordinary documents. So look what they're going to say. With the LLC Master Machine Asset Protection System, real empowerment to protect my assets is at my fingertips. It's very simple to understand. Best of all, the legal paperwork is prepared with the AutoDoc Prep software with the push of a submit button. Operating agreement, minutes, membership certificates, resolutions makes you legally and IRS compliant instantly. Hands down, this is the best investment I've made. Phenomenal workout. Thanks for what you do. And this is from John Gonzalez. He's from an investor from Colorado, and there it is, jg12@rocketmail.com if you want to email them and confirm it. These are real testimonials. These are not made up. And there's so many more I have, but we can only do so much. Let's move on. Plus, the superior documents of this system automatically replace the worthless documents of your existing LLC without state notification, totally private, without doing anything. Like magic, these documents can transform a debilitating, worthless LLC into a powerful vehicle of wealth protection, saving you and your family thousands every year. So these documents give you impenetrable legal protection. By the way, they're not on public records. They're totally private. But at your option, you can uncover them to use in a legal action. We tell you how to use that. Or without even showing them in a pending legal action. Let me tell you about my student, Natasha. Her LLC, I should say, engaged a contractor to do work on one of the LLC properties. The contractor did not do the job according to their written agreement and had a bad attitude about it. Does that sound familiar? Accordingly, she refused to pay the balance to this wrongful creditor. The contractor got a lawyer who wrote Natasha with the threat of a veil-piercing suit if she did not pay, and she had no intention of paying for good reasons. So using my system, she responded with this letter full of legalistic torpedoes. We call it the Power Attorney Letter, a real pal. Here it is. Dear Attorney, Preferred Property Associates, PPA, LLC, engage your client to do contract work on one of PPA's properties. According to the terms of the contractor agreement with PPA LLC, the contractor did not do a satisfactory job and therefore is not being paid the balance. All right, Torpedo 1. Bang. All agreements, correspondence, work orders, and company resolutions with the contractor were fully executed and done in the full legal name of Preferred Property Associates PPA LLC as a separate state statutory entity. Oh, what a missile that is. Next one, Torpedo 2. Bang. Preferred Property Associates PPA LLC has totally complied with all necessary entity formalities, including but not limited to a comprehensive operating agreement, minutes of meetings, resolutions, certificates of ownership units. He even uses the right exact terminology, meticulous to detail, all fully executed under seal and notarized on file. I hate to be a lawyer reading this letter. Torpedo 3. All LLC tax returns have been timely and properly filed with the appropriate taxing authorities with total compliance. That's a huge formality to prevent veil piercing. Torpedo 4, sinking the entire fleet. Bang. Okay. Also, the properties are heavily encumbered with debt. She used equity stripping, leaving negative equity like the crucifix against Dracula. Sincerely, Natasha Pizzarello, manager. Folks, after the lawyer read this, after they peeled the guy off the ceiling, what do you think he did? Wham, pal, ouch. You know, we'll never know because they never heard back from the attorney who probably told their client they would need a large front retainer, non-refundable, non-everything, non-contingent, dead on arrival. Natasha used the LLC Master Machine Asset Protection System, put the legal system in her favor, empowering her to rightfully defeat a wrongful creepo creditor and defeat an arrogant lawyer without having to use a lawyer herself. She saved at least $11,000. How many people are liking this? Yes. The PAL is another example of effective lawsuit prevention. That prevent lawsuits before they ever get off the ground that umbrella or any insurance does not give you. All right, now a problem is with your LLC formation in the Articles of Organization, a public document. In many states, you must include who the members are, the member owners who then become part of these public records. Well, in any state, my new system shows you how to be off the public records so you do not appear at all, with total privacy from claimants, lawyers, anybody who can cause costly, time-intensive legal actions, but not if they don't know you. Plus 5 more strategies to make sure you're invisible. You know, they made the movie The Invisible Man. Also, The Invisible Woman. Well, you're going to be starring in both of those movies, guys. All right. Plus, you will save hundreds, even thousands, as you can legally avoid filing expensive foreign entity registrations if your LLC is doing business in other states, as you're totally private and still protected. We tell you, we have a whole discussion on foreign entity registration. Out with your privacy strategies. Thank you for saving me $1,700 by not having to file foreign entity registrations. Vicky. All right, what else do we discuss in the system? The Series LLC, how good is it? This system has a far superior and cheaper alternative. If you don't know what the Series LLC is, the system explains it, but we have a better and cheaper alternative. 7 lawsuit prevention strategies to stop lawsuits before they would ever begin. How to reverse and avoid existing lawsuits. The 16 entity formalities already included to avoid veil piercing to prevent exposing your personal assets. When transferring existing property you own personally out of your name into an LLC, strategies to avoid transfer taxes in any state. Yes. Avoid mortgage due on sale clauses without lender interference. Avoid IRS costly tax traps. No side effects, guys. Save thousands. How to extract tax-free cash out of your LLC instead of highly taxed W-2 salaries. This is all fully supported by tax law sites. The 7 legal issues and 4 tax issues you must know when setting up your LLC for a totally well-oiled limited liability company. When, why, and how to use Wyoming as the LLC formation state, even if your property is not in Wyoming. Remember, entity selection, asset protection is an art as well, and here's part of that art when we make exceptions to make it more effective. Many more precious gems to protect you and your family. By the way, there's a new comprehensive, easy to follow online instruction manual with audio training and high definition, informative, fun. You're going to see and hear me reveal these great gems to protect you and your family. Great ease of use features, detailed table of contents for easy reference, larger print, user-friendly checklist, plain language, total cross-reference from the text to the audio and the audio to the text. Hey, Al, I read the new online text, took very little time, and listened to the audio. You are funny and on the money. Excellent. Even better than the former version, as good as that was. Now, that's Natasha. That's the one who wrote the power attorney letter, now known as the Bionic Woman, Italian style. All right. You will not get this newly created system anywhere else. I don't care if you go to the best law firms, the best CPA firms, your lawyer, your CPA, other speakers, nowhere but nowhere. Al, it purchased from just about all the so-called big-name asset protection speakers out there. Listen to them. I tell you, and you know who they are, and they're great guys. But I tell you, their courses are not even close to yours as the quality, content, ease of use, especially this new one. Thank you for saving me. And that's Muriel Thome from Winter Park outside Orlando, Florida. Thank you, Al. I purchased an LLC package from an asset protection expert, and he is a great guy, very well known, with some good material, but unlike yours, not real estate focused. I told you how important that is, but did hit my wallet. Okay, guy, Lance Carter. This system is for all types of real estate investors. Veterans, part-time, full-time landlords, buy and hold, wholesalers, rehabbers, commercial, paper. Yeah, if you do paper, notes, TLLCs, whatever. And beginners especially. Speaking of a beginner, Al, I filled out all my paperwork online in just a few seconds. Your instructions are very clear and easy to follow, and I can listen to the audio portions while driving. I have great confidence that I am well protected, both from lawsuits and the IRS. And this is from Rihanna Elliott, beginning investor. There is her email. And so many testimonials we are getting on this new system. By the way, we have superb customer service to support you using this system with 3 VIP benefits. VIP benefit 1, you get a 6-month email helpline directly to me for your questions with prompt expert responses. Hello, Al. Thank you for your concern. I can tell from the way you answer questions that you have a genuine concern for the success of your students. Even at 10 p.m., I don't sleep, guys, you answer with such concern. Not as if you're being inconvenienced. Thank you, thank you, thank you. And that's from Raincliffe, from Fairfax, Virginia. Very distinguished gentleman. VIP benefit 2, you can share the system with your attorney or CPA under a special licensing agreement if you think they're qualified. VIP benefit 3, we can refer you a top asset protection specialist knows my system at substantially reduced rates. But you know what? This system is so consummate, so complete. I don't think you need these 2 benefits. But they're there. They're your option. They're available if you want them. The total annual value of the VIP benefits, $3,000. I'm going to give you first 6 months free, $1,500. And you also get a VIP membership certificate when you get the e-system to complete to get all the benefits. The LLC Master Machine Asset Protection System, $1,395. The VIP benefits, $1,500. Total, $2,895. You know what? If you paid that, it would be worth it. But cross it out, make it $1,495. Hey, compare this to the $1,000 you're going to save in lawsuits, legal fees, and judgments, like Nancy, over $61,000. Or the lost business, the tens of thousands lost by the dry cleaners, plus the time, the stress, the aggravation, plus the savings from deducting your real estate education. Adam saved $5,800. I got students that saved more. Avoiding a lawsuit, Natasha saved over $11,000. Avoiding foreign entity registrations, Vicky saved $1,700. You know, these savings can be invested in real estate and IRA to grow to thousands. Plus, your investment is fully tax deductible with the IRS regulations. All right, cross out the $1,495, $895, $895. Brand new recreated e-system is sent to you digitally, so you get it to immediately save you thousands. Now, the distinction of this new system from other courses, including my other course, you know, I have my gold mine tax system. No, this is different. This is an asset protection system of carefully designed legal documents with meticulous detail specifically for real estate to effectively protect all of your assets from all kinds of legal actions without costly side effects. Albert, I'm so impressed with the extent and thoroughness that's evident in your materials. You left no stone unturned. It would cost a fortune, and it's right, in attorney and or CPA fees to come up with anything close. That's Jim Guinness from outside Boston, Mass. All right, guys, we're going to give you a $100 coupon off the $8.95, only $7.95, tax deductible. To order, go to the information on the screen to order. Now, let me ask you this. Where do you go from here? Who are you going to rely on? You have seen the choices, and none of them are any good. They're either incompetent or expensive or both. Why not have an automated, updated system that is already done for you with a legal team that would cost you thousands if you had to pay them, but you don't have to. We've done all the work. So your investment is only $7.95. Plus, I'm going to include a super quadruple bonus, free this event only. Super bonus 1, free professional LLC setups in any state with a fine company. You just pay the state fees. You got to pay them anyway. Any number of LLCs, you shouldn't have too many, but it's any number of LLCs. Now, by the way, this company that I'm going to give you a coupon code so there's no fee. Lawyers use them. A lot of lawyers use them, but they charge it. We have a limited number of those. Super bonus 2, an additional 6 months email VIP access to myself and my legal team. Now it's 1 year instead of 6 months. That's easily a $1,500 value. We have a limited number of those. Super bonus 3, my subject to report. Now, a subject to mortgage is where you, the buyer, takes over the payments of the seller's existing mortgage instead of being paid off. No need for bank financing with these great money-saving benefits. No bank of trauma. No, folks, there's only 2 ways to make money with a bank. Own it or rob it. Well, the first one's difficult. The second one's illegal. So we could be legal here. No upfront loan fees, no loan applications, no limited number of properties, little or no money down, little or no risk. Best of all worlds. Now, the big problem, remember, we address all the side effects. The IRS agents and CPAs are disallowing property deductions as you're not on the mortgage 1098, the subject to mortgage 1098. This is going to cost you thousands. But a solution included in this report is how to fully claim all property deduction. You know, they want to disallow everything, your depreciation, everything. Well, we're going to stop that. How to fully claim all property deductions or subject to mortgage, even if you're not on the original mortgage or Form 1098, in depth with complete tax law support, plus tax reduction strategies for the seller to help close the deal. Why subject twos are perfectly legal with legal precedent. More financing other than banks. In summary, this report includes the legal, the tax, investment, and financing aspects of subject to mortgages you will not get anywhere else. $500 value, free for those who order today only. We have a limited number. Super bonus 4 is brand new from my legal team. The Power Elite Trust, your pet. You got your pal, now you got your pet. Unlike any other trust, the pet is a superbly designed as 3 trusts into 1. It's a family legacy trust to protect your family if you're ever incapacitated, to care for minor or handicapped children, others, to automatically transfer your estate to your family without the delay, without the agony of expensive probate, without contest from unwanted heirs, ex-spouses, future gold-digging spouses. All this stuff happens. Con artists, etc. It also will save you on estate and inheritance taxes and more. It's also a privacy trust. Your personal assets are not in your name, but in the name of the trust. Again, you're invisible. And 3, it's an intrepid asset protection trust. Special provisions giving you ironclad protection, shielding all of your personal assets from claimants, lawsuits, lawyers, public exposure, even divorce. I mean, this is the greatest trust ever written, guys, and other eradicators of your wealth. Now, it privatizes and protects the following personal family assets: the ownership shares of your LLC and other entities. Now, folks, you don't put your investment real estate in this trust. You put your investment real estate in the LLC, and the LLC ownership shares in the trust. Now, you put your personal real estate, your home, your second home in this trust, your vehicles, your car, your boat, whatever, bank accounts, brokerage accounts, securities, annuities, etc., your personal valuables, antiques, rare collections, etc. Now, these assets have value, are subject to attachment and probate, but not if they're in the pet. You're totally protected, yet you control. Now, this is not a land trust, better called a real estate trust. A land trust or real estate trust is a revocable arrangement for privatizing and facilitating real estate transactions. Well, this is quite different, guys. In fact, that's what it is. It's an irrevocable life estate grantor trust is what it is in technical terms. Now, irrevocable means only you and your family can undo the trust, but claimants and their lawyers cannot. This, along with special trust provisions, is what gives you the impenetrable wall of protection, yet with the legal ability to revoke the irrevocable if you want to, but you don't really want to because of protection. Now, life estate means during your lifetime you have the full control, benefit, use, and income of the trust assets. Upon your demise, such assets go directly to your rightful heirs without delay, without probate, and without the possibility of contest, even better than a revocable living trust. Grantor means under Code Sections 671 to 678 that this superb trust has no adverse income tax consequences whatsoever, with no need to file tax return. It's totally IRS invisible. So the best of all worlds: probate avoidance, impossible to contest, trust management, privacy, asset protection, no negative tax consequences, no side effects. Now let's talk about the financial disasters with the pet. I'm going to read some of these. Now my cousin, this is disaster one. My cousin, happily married for many years with 4 great children. Unfortunately, he and his wife got divorced. Subsequently, he met some lush who could drink anyone under the table. They marry. A year later, he suddenly and tragically dies. Guess who gets his entire estate? The lush. Guess who got nothing? His adult children. It was not a huge estate, but $275,000, including a house, is not chicken feed. Suppose you were the children. How would you feel? Obviously, not very good. This family tragedy would have never happened with the Power Elite Trust. Let's go to disaster 2. Bob Bernstein, the dentist, had over $2 million in assets, including real estate. He is single with 2 teenage children, Bob Jr. and Roberta. After receiving, you never know when things happen. He got a flu shot. He should have took the vitamin C. But anyway, he got a flu shot. Bob Sr. became 90% paralyzed, incapacitated for 10 months. During this period, his children, who had access to Dad's funds, got swindled by a con artist with a Ponzi scheme for $486,000. This substantial loss would have never happened with the Power Elite Trust. And the third one came from one of my students, Thomas Berea from New York. Thomas, he had sent this to me. Disaster 3, about the real estate investor landlord who was sued by the parents of their son, a student who was a tenant of one of the investor's properties. The student tenant locked himself out. Well, get a locksmith or just break the window. Here's what he does. He scaled to the top of the house to get in, but fell and became permanently paralyzed. Very tragic. Then their lawyer realized the investor's LLC certificates were considered personal property, so the lawyer sued and won, wiping out the investor completely. End quote. In other words, to attach personal assets, instead of initially trying to collapse the LLC entity itself, the LLC front door, the lawyer went right through the LLC back door. See, your LLC is like your house. It's got a front door and a back door, and you got to lock them and secure both. Well, getting back to this, the lawyer went right through the LLC back door, attaching the investor's totally exposed LLC membership certificates to shares or units, and then collapsed the LLC entity to attach personal assets. This is a form of reverse veil piercing, a dangerous and very effective weapon against unprotected assets, as we just demonstrated. The solution would have been the Power Elite Trust. Put not your trust in money, but your money in trust, especially the Power Elite Trust. 2 different trusts, one for married spouses and the second one for an unmarried person, includes a comprehensive instruction guide included with this trust system. So this is another system. You're getting 2 systems. You're getting an LLC protection system and a trust system. The PET combined with a properly structured LLC via the LLC Master Machine Asset Protection System gives you awesome, formidable, impenetrable protection. Easily a $3,000 value. Attorneys told me they charge $5,000, $10,000 for this, but free for those who order today. Now, there's a limited number. Alert here. This trust bonus it's going to go away altogether, and we're going to sell it separately. So you want to take advantage of this now. Order now. Information on the screen. So let's look what we have. The Super Quad bonus, the free LLC setups, the additional 6 months Q&A helpline, now 1 year instead of 6 months, the subject to report, the Power Elite Trust. That's a $6,200. I mean, that's a low value, if anything, today only. All right, guys, limited supply, first come, first serve. First 15 people, orders will be counted 1 to 15. The order information is on the screen. You want to order as soon as possible. This special offer is for this event only, is not on any website or anywhere else. Order now. Now, we're going to give you an added bonus for the first 15. How many people like that Power Attorney? The PAL? Okay, we're going to include that. It comes with explanation instructions for use to save you thousands. Natasha is not the only one who saved with this. So let's just recap, and then we'll repeat the order information. With the Supreme System, the solution of total protection, your personal assets outside the LLC entity are protected from LLC property-related actions. Your personal assets are still protected for actions not related to the LLC or the property. The property equity within the LLC entity is protected. Events related to the property itself are protected without expensive tax results, without high IRS audit risk, without over-complexity, without costing a fortune, no side effects. All this for only a $795 tax-deductible investment. This event only. Order now. The information to order is on the screen. And you know, for those who are not impulse buyers, this is not impulse buying. It's intelligent investing into a legal protection system you will not get anywhere else, bar none, where the value exceeds the cost. So understand, the $795, it's not a payment, it's not an expense, it's an investment. It's an asset on your balance sheet where you're going to get returns far in excess of the tax-deductible investment. So please order now. The order information is on the screen.